Good morning, Your Honors. May it please the Court. Richard Levenstein on behalf of both appellants in this case, and these two cases have been consolidated for oral argument purposes, as Judge Sickland noted. The issue in this case was decided by the Florida Supreme Court and the First District Court of Appeal in the Seeger-Longwood cases, commonly known as the hospital governance law cases. The appellees in this case should not be permitted to do what was prohibited by those decisions of the First District Court of Appeal and the Florida Supreme Court by creating the Board of Trustees Fair Hearing and Appellate Procedure unilaterally and independent of the medical staff and outside the medical staff bylaws. In those hospital governance law cases, the law that HCA, the parent corporation of the two hospitals, including Longwood Regional Medical Center, had passed by the legislature, removed and or eliminated the authority and role of the medical staff in peer review credentialing and quality assurance by giving the hospital the authority to override decisions of the medical staff without reason or cause. It also gave Longwood, at that time, the additional authority to unilaterally amend the bylaws if the medical staff refused to approve an amendment proposed by the hospital governing body. It also, in Section 6 of that hospital governing law, created a fair hearing and appellate process similar to the one that is the subject of this case and which is at issue here, and which was to be used when the Board of Trustees rejected a recommendation of the Medical Executive Committee, very similar to the process that is the subject of this case.
Do the medical staff bylaws at issue in this case provide a review procedure in the situation where the peer review committee recommends reappointment, but the board rejects the recommendation?
They do not, and they did not at the time they were enacted, and they did not for 14 years after they were enacted, from the time they were enacted until this policy was put into place. And under the bylaws, a physician would be entitled to bring an action after a rejection by the governing body of a medical staff recommendation with regard to medical staff matters, which is what the medical staff bylaws presently and at the time they were initially created has read. There has never been, and there is no evidence of, any attempt by the hospital governing body to amend those bylaws, propose an amendment to the bylaws, or ask the medical staff to amend the bylaws to include any such process. And that would have been and is the way that if this type of a procedure was to be enforced and placed into effect and be bound to all of the medical staff members on the medical staff, it would have had to taken place. Our law is, as is the majority in the United States, is held by both the First DCA and the Supreme Court in the governance law cases that the medical staff bylaws are an enforceable contract between the medical staff and the hospital when executed by both parties. That occurred in 1992. Those bylaws have been amended since 1992, but again, there's never been an attempt to amend them to include any such procedure even resembling this process that we're here to talk about today. And it's important to note the timeline of these events. The First District Court of Appeal decision was rendered on June 21st of 2007. The Board of Trustees policy was put into place on July 11th, 2007. And the Florida Supreme Court rendered its decision in the hospital governance law case on August the 28th of 2008. So only after the First District Court of Appeal had affirmed the trial court's summary judgment striking that law as unconstitutional and therefore eliminating Section 6 of the law, which provided for that fair hearing and appellate process in the law, did Longwood create this policy in 2007 in between the two decisions. And even after the Supreme Court's decision on August 28th of 2008, which in effect struck the law and confirmed the unconstitutionality of it, including that fair hearing and appellate process, which at page 11 of that decision it addressed as being something that gave the governing body basically the control over peer review, credentialing and quality assurance without medical staff participation, because that law allowed the hospital to basically override any recommendation of the medical staff, and also, in the event the medical staff did not agree with a proposal to amend the bylaws within 75 days, that amendment became an amendment to the medical staff bylaws. So it gave the administration the right to unilaterally amend the medical staff bylaws. All that was stricken by those two decisions. This process that we're here to talk about is the same, or virtually the same process as is contained in Section 6 of the Hospital Governance Law, which the court struck as being an impairment of the medical staff bylaws, and therefore could not be utilized to unilaterally amend them, and therefore this court should be bound by those two decisions in reviewing this process from a legal perspective as not being a process that can be, in effect, forced upon members of the medical staff of this hospital, and in particular, in this case, Drs. Desai and Keller, through the unilateral imposition outside the medical staff bylaws contract of a provision which is contractual in nature. Now, there have been arguments in the briefs with regard to whether or not, when Dr. Desai and Dr. Keller submitted their applications for medical staff privileges, that somehow that they agreed to be bound by this appellate process and fair hearing procedure. That is incorrect. And it's incorrect because even if you take the literal meaning of those undertakings and applications, what they reference are the medical and hospital bylaws, and our position is that inclusion of the hospital bylaws was a typographical error because it only appears one time, but it's really irrelevant to this argument that I'm making. But it's something to consider, for the court to consider. When they signed those documents, they referenced that they agreed to be bound by the medical staff bylaws, the medical staff rules and regulations, and the hospital bylaws, which we again say is a typographical error, and any policy of the hospital. There is no such language in this fair hearing and appellate process that we are here talking about today. In fact, it is entitled Board of Trustees Fair Hearing and Appellate Review Procedures. It is not contained in the hospital's bylaws, and even references that if it is inconsistent with the hospital's bylaws, it governs.
What about your opponent's suggestion, though, that even if that's the case, it really doesn't matter because we have Florida statutes and administrative rules here that would control this?
Well, that was one of the arguments that was made during the hospital governance law arguments. And the court said no, that you have to amend the medical staff bylaws if you're going to try to impair existing rights of practitioners that are contained in those medical staff bylaws, which are a contract between the medical staff and the hospital governing board. So that's not an argument that is to be made here, and only if there was some proof that there had been an attempt by the hospital to amend the medical staff bylaws to include this type of a process, would that have any relevance or any validity? And then my argument, even if that was the case, and it's not, would have been that judicial intervention would have had to have been sought to reform the bylaws to include a provision in those bylaws to cover that legal requirement, if that was the case. Never was that done. There's no evidence of it. And as I said, between 1992 and 2007, when the policy was put into place, the bylaws operated as they were without this fair hearing and appellate process. It is not coincidental, I submit, that this fair hearing and appellate process was created in July of 2007 after the First District Court of Appeals decision affirming the trial court's summary judgment striking down the governance law, and the Supreme Court's decision of August 28, 2008, affirming that decision of the first DA, striking that law, and specifically referencing in that decision, and I'd like to refer to it specifically, some references to what Justice Pariente wrote in that decision. And in particular, Your Honors, if we look to page 11 of that decision, there's a reference on page 10, and it gives the text of section 6, which was the procedure that was similar to the one we're here today. And what she wrote was, Justice Pariente wrote, further under the HDLA, The medical staff's role in the area of staff membership has been all but eliminated. The medical staff bylaws provide for a credentialing committee consisting of members of the medical staff to review the credentials of new applicants for all categories of staff appointments and clinical privileges, and to make recommendations to the board. The role played by the medical staff in the area of appointments to the medical staff is set forth in Article 6, Part A of the bylaws, and provides that persons who may admit patients or practice medicine in the hospital shall be appointed to the medical staff after recommendation of the Medical Executive Committee and upon approval of the Board of Trustees. The bylaws further provide that ratification of the medical staff decision, and it says or, but it's been held to read on, medical staff matters shall not be unreasonably withheld. And that's in the medical staff bylaws today still. Yet the right to override these recommendations without any meaningful checks or balances has been granted to the board by the HDL. And then the court went on to say, moreover, in Section 5 of the HDL, as well as in Section 6, and Section 6 was the fair hearing and appellate process part of the law, the entire process for peer review is altered to once again provide the board, and ultimately the hospital, control over the peer review process. Section 6 requires the medical staff to act within 75 days after a request from the governing board regarding actions against an individual physician, and also allows for the creation of a conference committee to second-guess the medical staff recommendations. Neither this 75-day requirement nor the conference committee process is contained in the current bylaws or in the law of this state. Section 6 also provides the board with the right to override the recommendation of the peer review panel or the medical staff's recommendation for staff membership, clinical privileges, or quality assurance without any uniformly applied reasonableness or good cause requirement, as does this policy and procedure, as was previously required by the medical staff bylaws. This fair hearing process and appellate procedure is not a fair hearing nor an appellate procedure. What it provides is the authority to the hospital to, in effect, select the hearing officer, select the panel members of the fair hearing, select the members of the appellate panel, all who are reviewing a decision of that very board. And they have the right to reject the board does, reject the finding of the hearing panel, which was reviewing its decision, and it has the right to reject the appellate decision of the appellate panel, which is reviewing the board's original decision. That is exactly what Justice Pariente wrote about in the governance law. And then she wrote in that decision, in sum, the previously existing medical staff bylaws established a framework for cooperative governing in which the medical staff plays an important role in the recommendation of candidates for appointment and credentialing, peer review, and decisions on contract-based services. The framework for governing and the medical staff's important role in it pursuant to the bylaws is altered by the HDL in a manner favorable to the board by the many rights conferred to the corporation, in which the HDL essentially gives the board plenary power to take independent action in these areas. And that's exactly what this fair hearing and appellate process does. And at minimum, these multiple facets of the HDL grant Longwood a right and place it in an advantageous position, one that it did not possess before the law was enacted. The similar argument we are making is that the passage and imposition of this fair hearing and appellate process upon members of the medical staff is no different than the hospital governance law's creation to be imposed upon members of the medical staff. And
could you talk a little
Yes.
bit, if you would, about the whole issue of access to courts? I mean, as you know, your opponent suggests this has nothing to do with access to courts because once, in fact, you exhaust administrative remedies, then you have the key to the court.
I'd be happy to. In order for administrative remedies to be applicable to a party, that party either has to be subject to a statutory scheme that provides for it, such as the Administrative Procedures Act covering government employees, or a private person has to have signed some agreement that entitles the employer or other party to require that those remedies be exhausted. In this case, there is no such agreement and there is no such statute. And the attempt by the appellee fails because in every document related to this procedure, never is the word required utilized. In the letter that Dr. Desai and Dr. Keller received from the hospital with regard to the fair hearing and appellate review procedures, it indicated they were entitled to avail themselves of these remedies. In the actual Board of Trustees Fair Hearing and Appellate Review Procedures text, it says in the first paragraph, a practitioner who is a medical staff member or an applicant for medical staff membership shall be entitled to these fair hearing and appellate review procedures as applicable whenever a proposed action has been taken by the trustees which will or may adversely affect him or her. Nowhere is the word required used. Nowhere is the word exhaustion of administrative remedies is required by some rule, regulation, bylaw, or agreement. These policies simply are not binding absent some statutory scheme that makes them binding or an agreement by the parties.
I didn't want to interrupt when you were reading that, but doesn't the Florida Administrative Code say the governing body shall establish a procedure for an applicant for privileges to appeal an adverse decision?
In the same, I didn't know if you were complete.
Yes, go for it.
Excuse me. Only in the paragraph of the Administrative Code that references the medical staff bylaws and what is required to be placed in them. And the governance law, in that decision, there were arguments raised that the law required that these provisions that were in the governance law be included and that the hospital administration, therefore, was entitled to have that law passed. And they were rejected by the Supreme Court. And the Supreme Court rather said, when it did not permit Section 6 of the statute to stand as a severable portion, struck it as unconstitutional, that it impaired the medical staff bylaws contract, and if there was to have been such a procedure, it had to be placed in the bylaws, and it had to be subject to the mutual consent of the parties. There is no evidence that any agreement or any statute requires these doctors to have exhausted these remedies. I'd like to save some time for rebuttal. The only other thing I'd like to say is the amicus brief that were filed by the 41 hospitals should not be considered by this court. Those 41 hospitals have their own sets of bylaws. They do not in any way resemble these bylaws. Their arguments are merely that doctors should be required to exhaust administrative remedies in all cases, and that's not what we're here about, John.
Great, thank you.
May it please the court, I'm Tom Warner with the law firm of Carlton Fields, representing the appellee in this case, Lawnwood Regional Medical Center. I have with me today my partner Dean Morandi and my associate Mike Sloan. I will respond directly to the presentation of my opponent here this morning, but before I do, I'd like to make a point and point out that there is a deficiency, if not an error, in our answer brief to this extent. On page 23, we cited the case of Florida High School Athletic Association versus Melbourne Central Catholic High School, 867 Southern 2nd, 1281, 5th DCA 2004. I say it's an error because we cited it on page 23. We should have cited it on page 1 of this brief. The Florida High School Athletic Association case is directly on point and quite frankly decisive of the issues in this case, which are, is there available or was there an available administrative remedy, and did the appellant here fail to exhaust it? That case had to do with a high school student who was declared ineligible for the football season, and instead of following the appeal process which is provided by the High School Athletic Association for when you're declared ineligible, they went to court and got a temporary injunction. The 5th DCA reversed the injunction and held that the student was required to exhaust his administrative remedies. The point, though, and why it is so important to this case is the student didn't agree to anything. The student was not a member of anything. The statutes which authorized the Florida High School Athletic Activities Association to regulate high school athletics, the statute required them to provide an appeal process for adverse decisions on eligibility. That's exactly the same circumstances in this particular case, and that case is determinative of the issues in this case. There was no express agreement to be bound, obviously, but it was required by statute. And the opinion cites the statute, by the way, which doesn't say a student must do this or must do that. What it provides for is that the athletic association must provide for the appeal. Now, responding more directly to my opponent, the Seeger case has nothing to do with what we're doing here today. The Seeger case declared unconstitutional a special law that applied to only one hospital in the state of Florida and gave that hospital, Lawnwood, the right essentially to override the medical staff bylaws. And I'm not here to contest that holding at all. It is what it is. That special law gave the right of the hospital to overcome or override the medical staff bylaws. And the court said, this is a kind of a law that benefits one corporation and it's unconstitutional in the state of Florida. The point here is that statutes, as pointed out by your honors, require the hospital, all hospitals in the state of Florida, to provide a provision for appeal. Now, this court has already determined in a prior appeal in this case that the Board of Trustees of the hospital has the final say-so on whether to grant medical staff privileges or to deny them. They have the final say-so. So when the applicants, such as Dr. Desai or Dr. Keller, go through the process and they get to the MEC makes the recommendation, but the board has the final say-so. And if the recommendation is favorable and the board decides to deny medical staff reappointment, they are required by law to provide a procedure for an appellate review of that decision. And so the board has adopted a fair hearing and appellate review process that does apply. It was available to the doctors, and they chose not to pursue it. Now, my opponent makes the point that they're not bound because they never expressly agreed to it. And of course, our position is under the law, and quite frankly, all the general law, on exhaustion of administrative remedies, there's no, and my opponent can cite no case that says that you have to expressly agree to it. The law is if you have a remedy available, you must pursue it before going to court. Nevertheless, in this particular case, the medical staff bylaws do provide that an applicant for medical staff membership agrees to abide by the hospital and medical staff bylaws, rules, and regulations. They also signed an undertaking and affirmation when they apply for membership. And my opponent indicates that there must be a typographical error because it says hospital in addition to medical staff bylaws. Well, first of all, that's the first time we've heard that argument. That argument was never raised until the reply brief in this particular case. But I would point out to the court that if you look at the oath and affirmation, or the undertaking and affirmation that these doctors signed, he's only looking in one place where it says hospital and medical staff bylaws. There's another paragraph below it which refers to the facility and medical staff bylaws, rules, and regulations. So it's pretty clear that they did, in fact, agree to be bound by the Board of Trustees' rules and regulations in addition to the medical staff bylaws. But again, that's not the law. My opponent says that a private person has to agree to be bound by the administrative remedies. Well, he cites no case for that proposition, and no case exists. As I pointed out to you in the High School Activities Association case, that if the law requires it and it's available, then you must pursue it before going to court. And I think the final point that I would like to make is this. The doctrine of exhaustion of administrative remedies is a judicially created and enforced doctrine. It's based on the concerns for judicial economy and efficiency and a concern to give some deference to certain administrative matters that require special expertise, etc. That is in harmony, in this case, with the state statutes that provide for peer review and credentialing applying to all hospitals in the state of Florida. And if you look at the provisions of the state statute which grant immunity from suit, except in extreme circumstances such as intentional fraud, which declare the records of the peer review process and credentialing process to be confidential and inadmissible in court. And then, of course, the state statutory provisions that require all hospitals in the state of Florida to have an appellate review or an administrative hearing process that someone can take when there's an adverse decision to them. So if you take all that together, it's clear that the idea is that these cases should not be in court unless and until the administrative process has been completed. And that's the whole idea behind the judicial doctrine and the idea behind the Florida statutes that provide that. And that is why 41 hospitals filed an amicus brief in this particular case. And I might point out, we are 8 years into litigation with multiple appeals in these cases. And had we gone through the administrative process and completed it, I don't know what the outcome would have been. But here we are 8 years later, still dealing with these problems, and that's certainly not what was anticipated by the statutory scheme nor the judicial doctrine.
You referenced the prior appeals. What, if any, impact does the prior opinion from this court in this case have on the issues today?
The failure to exhaust administrative remedies? Yes. Well, I'm glad you asked.
I know we remanded for dismissal, and
Correct.
then there was a motion to dismiss filed, and amended complaints, et cetera, but.
Well, we obtained the opinion from this court, and in that opinion, the court stated that it did not rule upon the issue of exhaustion of administrative remedies because it found that the hospital was immune from suit and ordered that the case be dismissed. When it went back to the trial court on remand, we took the position that dismiss meant the case should be over. But there was some ambiguity about that, and quite frankly, we asked for rehearing in this case, which was denied, so it wasn't decided. So, I mean, as I see it, the law stands, and the decision of this court stands that we were immune until they started amending again, but the issue of exhaustion of administrative remedies was never ruled upon. We wish it had been. So, but I don't think it precludes or dictates any particular judgment of this court at this particular time. With that, I will conclude my remarks, but I will leave it with this point. We request respectfully that this court affirm the judgment of the trial court below, and we will take that affirmance in whatever form that we can get it. However, I would ask the court to respectfully consider that it would, with the interest of the other 41 hospitals and the interest of this issue throughout the state of Florida, that we request an opinion that affirms the trial court's order of dismissal with prejudice on the basis of failure to exhaust administrative remedies, and an explanation that healthcare providers, physicians who are dissatisfied with the results of their credentialing and peer review must exhaust their administrative remedies before going to court. Thank you.
Thank you.
Let me address the Florida high school versus Melbourne case first. Every athlete who participates in a high school sport is governed by the rules of the association of which that school belongs in terms of participating in a sport. That's why the appellate procedures or the administrative procedures applied to that athlete in that case. That case has no applicability to this one because there is nothing analogous to that factual situation and this one. The Seeger case, I read substantial portions of Justice Pariente's opinion to your honors, and I'll leave it up to the court to determine if all it held was that that law was unconstitutional because it was a special law, and submit that that's not the major holding of that case.
But do you think there's a lot of dicta in that case? I mean, is that fair to say? And If so, how much?
I don't think it was dicta because it was the
Well,
basis.
is there a lot of dicta? I mean,
There was, Justice Pariento went into great detail as to her opinion, but that detail is not dicta because it was the basis for the decision that she reached in creating that opinion, with all due respect, Your Honor.
I'm just asking, I'm not taking a position.
The final say is given to the Board of Trustees subject to the provisions of the medical staff bylaws. In these bylaws, that discretion is limited to be reasonable and with just cause when rejecting a medical staff recommendation. And that's in Article 11, Section 3 of the medical staff bylaws. An available remedy is not equivalent to a required remedy. The oath and affirmation referred to by counsel, there is no reference to this procedure in it, that the doctors agree to be bound by it. This procedure is not a rule or regulation and is not part of the hospital bylaws. If this was such an important part of the medical staff's governing documents, then it should have been specifically referenced in those documents. If I have an employee who I have an employment contract with, and that employee has a dispute with me over my employment relationship with he or she, I cannot create unilaterally an administrative process and say, here's the administrative process I created that you now must exhaust before you can sue me, unless that employee or other party had agreed to be bound by such a process. That is exactly what this case is about, and it is not in any way supported. The position taken by the appellee is not in any way supported by the arguments that were made today. These decisions should be reversed. All of the prior decisions dismissing the counts should be reversed, and these cases should proceed. If the Supreme Court had found that there was a necessity to have an appellate process in the hospital governing law case, it would have left Section 6 of that law intact, and it did not. As far as my last comment is regarding the Desai appeal, the Desai appeal that this court rendered an opinion in was based upon a granting of an injunction, not upon a full evidentiary matter. It did not render an opinion or a ruling on whether administrative procedures were required to be exhausted. And this issue is squarely before this court on these two cases. And it's a motion to dismiss, and the allegations of the complaint clearly sustain the causes of action asserted, and there is nothing to support the requirement to exhaust administrative remedies that are neither statutorily imposed or agreed upon by the parties in question. Thank you.
All right, thanks, folks. All right, our last one up is Kelvin